My name is Serena Salinas, and I'll be presenting the first half of the Scotus required cases. Marbury v. Madison, 1803. Facts. William was an appointee for the Justice of the Peace in Columbia and was one of the appointees that didn't get his commission because of James Madison. The holding of this case is Marshall declared the act unconstitutional, establishing the principle of judicial review, which is the power to declare a law unconstitutional. The reasoning behind this is Marshall concluded that the court would not issue a writ of mandamus, so he reasoned that the Judiciary Act of 1789 conflicted with the Constitution. At the time, Congress did not have the power to modify the Constitution through regular legislation because the Supreme Clause places the Constitution before the laws. The decision of this case is the establishment of the principle of judicial review. The court had no opinions on this case. McCulloch v. Maryland, 1819. Facts. Maryland passed a law that forced all banks to pay a yearly tax, but the chief officer, James McCulloch, refused to follow the law. The holding of this case is Congress has the power to establish a bank, so Maryland cannot tax a national bank. The reasoning behind this is a national bank is necessary to effectuate Congress' enumerated powers, and states cannot interfere with Congress' exercise of its power. The decision of this case is states cannot tax national banks. The court had no opinions on this case. Schenck v. United States, 1919. Facts. After World War I, Congress passed the Espionage Act, which did not let people spread lies about the Army. Social Party leader Charles Schenck went against this law by stating that it violated the 13th Amendment. The holding of this case is Schenck's speech posed a clear and present danger to the United States. The reasoning behind this is his speech would be protected, but when there's war, limitations of rights are permitted. It depends if the words he used would create a potential danger to the United States. The decision of this case is the First Amendment right can be limited if it possesses a potential threat. The court had no opinions on this case. Brown v. Board of Education, 1954. Facts. Linda Brown, a young black woman, was denied from attending a school closer to her home because of her race, leading to the Browns to feel like the board violated the Constitution. The holding of this case is that segregation in public schools is a violation of the 14th Amendment, making it unconstitutional. The reasoning behind this is public education is necessary for children to prepare for the future, making it a right that must be available to everyone on equal terms. The decision of this case is separating children in schools is unconstitutional. The court had no opinions on this case. Baker v. Carr, 1962. Facts. Tennessee had not assigned new state legislative districts since the 1900s, causing for there to be inequality that is brought up by Charles Baker. The holding of this case is the federal court has jurisdiction on deciding constitutional questions about state legislative boundaries. The reasoning behind this is the federal court has the power to decide cases under the Constitution or federal law, which this case arises under the Equal Protective Clause. The decision of this case is courts can redraw voting districts so that every vote can be equal weight. The opinion of this case is there's nothing in the Constitution that requires equal representation, so this question should be left to the legislators or the political system to decide. Angle v. Vitale, 1962. Facts. New York Public School authorized a prayer that was optional to start off the school day. 10 parents sued a school board because it made the prayer a daily requirement. The holding of this case is this is a violation of the Establishment Clause because the government can't sponsor a prayer. The reasoning behind this is the Establishment Clause creates a separation between church and state, forbidding the government to support religion. The decision of this case is that states cannot hold prayers in public schools. The opinion on this case is the prayer is similar to many other examples of religion in public life. Gideon versus Wainwright, 1963. Facts. The federal government had to provide a lawyer to any person accused of a crime if they can't afford one, but the court also stated that the state did not have the same duty, leading to Gideon filing a habeas corpus petition. The holding of this case is the right to counsel is necessary to have a fair trial. The reasoning behind this is the court agreed that it's necessary for a fair trial, so it overruled the 1942 case. The decision of this case is the guarantee of legal counsel for criminal defendants. There was no opinions on this case.
For the second half, I, Emily Hernandez, will be presenting Tinker versus Des Moines, 1969. Brief facts. 5 students went against school ban and wore protest symbols for the Vietnam War, bringing to question the First Amendment freedom of speech. Brief holding. The court held that the students did not lose their rights to the First Amendment when they stepped into school. Brief reasoning. The court expressed that the school officials cannot forbid only on the suspicion that speech might be offensive in the learning environment. Decision. The Supreme Court ruled in favor of Tinker, stating that the fear or concern of disturbance is not enough to prohibit freedom of speech. Dissenting opinion argued that the First Amendment did not grant them the right to freely speak opinions, also stating that it was a distraction to students. New York Times versus U.S., 1969. Brief facts. Daniel Ellsberg, former military analysis. Illegally copied classified reports and were leaked to major publications about the United States' involvement with Vietnam. Brief holding. The court held that the government did not overcome the accusations against the press, did not overrule prior restraint of the press. Brief reasoning. Reason that publication would not cause an inevitable, direct, and immediate reaction, endangering the American forces' safety. Prior restraint was unjust. Decision. Ruled 6-3 for the newspapers, concurring that the court can never prohibit the publications of press as it violated the First Amendment. Dissenting opinion. Complained that the court rushed its decision on the matter, criticizing that the First Amendment right itself is not absolute, characterizing the matter as a parody of the legal process. Wisconsin versus Yoder, 1972. Brief facts. 3 parents refused to send their children to school after 8th grade, arguing that high school did not align with their religious beliefs. Brief holding. The court held that the free exercise of religion under the First Amendment exceeded the state's interest in compelling school attendance beyond the 8th grade. Brief reasoning. Reason that due to their beliefs and history of the Amish, supports the claim that education would gravely endanger, if not destroy, their beliefs. Decision. In favor of Yoder, due to the free exercise clause held under the First Amendment. Dissenting opinion. A partial dissent, only because they weighed focused on the parents' free exercise claims, not the children, and if they wanted to attend school beyond 8th grade. Shaw versus Verno, 1972. Brief facts. The state legislature created a new district map that included one majority-minority district and submitted it towards looking for its approval. Brief holding. The court held that although North Carolina's reapportionment plan was racially neutral on its face, it constituted an effort to separate voters into divisions based on their race. Brief reasoning. Classifying citizens due to race conflicts with the ideals of equality. Geographic distance only enhancing commonality is race. Decision. Ruled a 4-5 decision in favor of Shaw. The classifications of citizens primarily on race are unwanted in a free society, in conflict with the political views of equality. Dissenting opinion. Only discriminations intentionally harmful towards racial minorities is protected by the 14th Amendment. U.S. versus Lopez, 1995. Brief facts. Alfonso Lopez was charged under the Texas law with firearm in possession on school grounds, but Congress had no right to pass the law. Brief holding. The possession of a gun is not an economic activity, therefore it does not have a significant effect of interstate commerce. Brief reasoning. Carrying a gun on school grounds is not an economic activity. Ran through a substantial effect, there was no evidence found that the possession of a gun on school grounds affects the national market of guns. Decision. Ruled in favor of Lopez, 5-4, to claim that any kind of activity is commerce Any kind of activity is commerce means having the power of Congress have unlimited power. Dissenting opinion. The Commerce Clause includes the rights to regulate local activities as if the activities affect the interstate commerce education as a factor of affecting interstate commerce. Therefore, the destruction of guns can strafe away from education. McDonald versus Chicago 2010. Brief facts. Several suits filed against Chicago and Oak Park in Illinois challenging their gun bans. Brief holding. Held that the 14th Amendment makes the Second Amendment right to bear arms for the purpose of self-defense suitable to the states. Brief reasoning. The Second Amendment qualifies as it protects an individual's right to possess a firearm for self-defense on state. 14th Amendment made that possible. Decision ruled 5-4 in favor of McDonald, concluding that the Second Amendment rights are fully applicable to the states under the 14th Amendment. Dissenting opinion argued that the Second Amendment had no text history, or underlying rationale that characterized its fundamental right, guaranteeing its incorporation into the 14th Amendment. Citizens United versus FEC 2010. Facts. Brief facts. The movie was conjured to express opinions about whether Hillary Clinton would make a good president. Brief holding. The majority held that under the First Amendment, corporate funding of political broadcasts and candidate elections cannot be limited. Brief reasoning. Political speech is essential to a democracy, which is no less true because it came from a corporation. Decision ruled 4-5. The First Amendment prohibits limits on corporate funding through broadcasts towards candidate elections. Dissenting opinion. First Amendment protects people, not corporations, as funding overwhelms the debate and overshadows non-corporate voices. Scotus required cases presentation concluded by Emily Hernandez.